only then there will be a binding contract. I'll move on. I think already we have crossed 1 hour time, but still I'll brush it up, right? Whether the transfer clause is mandatory, definitely this is mandatory, right? So it is because of exigency of service, incident of service, right? So it is better the management mentions this clause in the appointment order, so that the management can retain its right to transfer a person from one department to another department, from one shift to another another shift, from one place to another place, from one branch to another branch, which are in existence or which will be maybe started on a future date, or from one group company to another group company, or from one company to another company in which the management has got interest. You can, I think it should be very, very elaborate. Only then there will be a right? But so if you have the standing orders, particularly certified standing orders, if there is a transfer clause, then it is fine. But even then, I would suggest because this will re-emphasize, right? Because again, technically the standing orders will be applicable only to the workers as defined under Standing Orders Act, which means as defined under the ID Act, right? So for others, it may not be applicable. So for transferring, for retaining the right to transfer the other persons, it is better to make this mention this clause in the appointment order. It is always better. So it will be applicable for both workers and the other persons. Similarly, I think I have given certain case laws. You can just go through that. And similarly, the retirement clause. See, technically, if we are not mentioning the retirement age in the appointment order, we cannot retire a person unless and otherwise, again, it is there in the certified standing orders, right? So it is always again better to mention this. Again, same thing. Standing orders may not be applicable to all the employees. So it is better, even if it is mentioned in the standing orders, you again mention it in the appointment order also. Again, I have given few case laws for this. Execution of bond, yes, it is not totally barred, it is not void, right? You can get it executed by the person because the party who breaches the contract shall indemnify the other party if there is any loss, right? So I think I'll move on because this is a classic case law. We are of the opinion that the amount of rupees 10 lakh mentioned in the bond is a genuine pre-estimate of the damages which would be incurred by the plaintiff in the event of abrupt leaving of the services. Therefore, we do not find any infirmity in the judgment and decree passed by the court below. There is no compelling circumstances to reverse the judgment and decree of the trial court. There is no merit in the present. So this is regarding the first officer. So lady pilot. So she was supposed to serve the company maybe for 3 years post the training, but I think she wanted to leave after completion of 2 years. So the court clearly said she has to pay the compensation. So that loss incurred for providing training, that can be definitely recovered. It is possible, right? But we cannot come up with conditions like maintaining confidentiality post-employment. It is not possible, right? We cannot, or we cannot compel a person to not to join a competitor post-employment again after resignation. Again, or to start his own business on the same lines. Those are all considered as maybe illegal restrictions. It is against section 27 of the Contract Act. So can an employee be prevented from joining a company? I think we discussed on this. We cannot prevent. So see, so once the person leaves, he can join anybody, even the competitor, right? After post the employment, we cannot compel the person not to join a competitor or not to start a business of his own or not to reveal whatever he has learned in our company. I don't think those restrictions are legally valid. It is not possible. Then I think post-employment restriction, this is again Pepsi Foods case. The court has held that admittedly in the service and the employment contracts of the plaintiff, there is a negative comment. See, it's a restriction, right? But restraining an employee from engaging or undertaking employment for 12 months after he has left so I don't think this is considered as against law. So notwithstanding that it is well settled that such post-termination restraint under Indian law is in violation of section 27 of the Indian Contract Act 1872. So this particular section is very, very crucial. So restricting a person from doing some trade or some profession as per this section 27 of the Indian Contract Act is not valid. It cannot be enforced.